seminar. Today, it has been 4 days on the seminar of criminal justice system, and we have learned all the good things and the most important things on the criminal law by the learned advocates and the intellectual faculties. Today we have with us Dr. Rajesh Singh, Associate Professor from the Department of Law, Parul University, Vadodara. Today his topic will be bail provisions in India and its development. Sir, I welcome you all and welcome you too on behalf of Sri SMSA Law College. And I now hand over to you this session to deliver your speech. Sir, we are very thankful to you. Please enlighten us with the provisions of the bail. Thank you, sir. Over to Rajesh, sir.
Thank you, Dr. Mahesh sir, and all the faculty members from Mehsana Law College. It is a great privilege that you have been invited me for delivering this lecture. My lecture topic is bail provision in India and its development. So, as per the origin is concerned, the concept of bail can be traced back to 399 BC, when Plato tried to create a bond for the release of Socrates. Now, as you know that bail is a rule and jail is an exception. You have heard various judgments and you find that this is the basic principle of the bail. And as per Article 21 of the Indian Constitution guaranteed the fundamental right to freedom of every citizens of India, which specifically state that no person shall be deprived of right and personal liberty. Now, as per the meaning is concerned, bail in a law means the procurement of the release from the prison of a person awaiting the trial or an appeal by the deposit of the security to ensure his submission at the required time of the legal authority. The monetary value of the security is called as a bail bond, and value is set by the discretion over the courts, because court has a wide discretionary power to grant a bail. Now, first, let us understand what is a bailable and non-bailable offenses. The distinction between the bailable and non-bailable offenses is based on the gravity of the offenses. The Honorable Court first check while granting the bail that whether the gravity is lower or very higher. The Honorable Court also check the danger of the accused absconding, whether he is going to abscond, tampering of the evidences, and previous conduct, health, age, and sex of the accused person. So these are the various important ingredients while checking the bail application. Though the schedule for the classification of the offences as bailable or non-bailable is provided in section 2A of the CRPC as a bailable offence, means an offence which is shown as bailable in the first schedule or which is made bailable by any other law for the time being in force, whereas non-bailable offences means any other offences. However, it is mostly the offences which are punishable with imprisonment of not less than 3 years that are classified as a non-bailable offences. So, bailable offences are the serious offences and non-bailable offences are not serious, but if it is less than 3 years, then it is considered as in the non-bailable offences. Now, bail provisions in the case of bailable offences. Now, as you people know, as a student of the law, that as per section 50 of the CRPC, that is Criminal Procedure Code, whenever a person is arrested without warrant, it is the duty of the police officer to communicate the full detail of the offense for which the person is arrested. Also, if the offense for which the person is arrested is a bailable one, it is the duty of the police to inform that he is entitled to be released on bail after giving COT. Sometimes police has to tell to, because some people do not know that whether they are able to apply for the bail or not. So at least in the non-bailable offenses, the police officer has to tell that yes, you are entitled for bail, you can apply. Okay. Now, what is the procedure? In order to apply for a bail, in the case of a bailable offenses, the person need to fill a form of bail. That is form number 45, which is given in the first schedule, and apply for a bail, and the court will have to grant bail. Now, section 436 provide for the release on bail of a person. As per section 436 is there, that it says that it provides for the release on bail of a person accused of a bailable offense. And section 436 of the CRPC is mandatory in nature. And the courts or the police have no consideration in the matter. And any accused person arrested for a bailable offense willing to provide bail must be released. The only discretion available with the police is to release the accused either on a personal bond or with the sureties. In the cases where the accused is unable to provide bail, the police officer must produce the accused person before the magistrate within 24 hours of the arrest, as specified under section 57 of the CRPC. Subsequently, when the person accused of an offense is produced before the magistrate and is willing to furnish bail, then the magistrate must release the accused person. And the only discretion available to the release either on the personal bond or the bond with the sureties. Now, after the judgment of Arnesh Kumar, now in the case of cruelty matters also, the police is having a power to grant bail, and the magistrate cannot authorize the detention of a person who is willing to furnish bail. Now we suppose, now you know, if a police is arresting a person and because in 24 hours he has to be produced before the magistrate, and a person has a right of a bail and he can apply for the bail, and while putting a bail bond he can get a bail, or he can also put the sureties, then and then after also he can get a bail. And you know, as for the sureties, because why the sureties are to be submitted to the magistrate, so that the person should not abscond or should not run away from the jurisdiction area. Now coming to bail provision in the cases of non-bailable offenses. Now, provision as to the bail in case of a non-bailable offense is laid down in section 437 of the code of the CRPC. This section gives the discretionary power to the court other than the High Court or Court of Session. Means you can apply in 437 before the magistrate. You cannot apply in before the Session Court or before the High Court to release an accused on bail in a non-bailable cases. It lists down the circumstances when bail will not be granted, or when shall bail be granted with a specific conditions, etc. Because you know, when you are going for the bail application before the magistrate also, you have to put the conditions of the bail. Then the magistrate will read out, and then if it think fit that yes, this can be granted bail, this application can be granted, he can grant bail. Now, a person, section 437 specifically state that a person accused of a non-bailable offense means he has done certain severe offenses, does not have a right to release on bail, but bail can be granted at the discretion of the court. So it is a power to the magistrate that whether he will think that yes, the condition of bail bond condition is fulfilled, then and then magistrate can grant a bail in section 437. But no session court and high court has a power to grant bail, subject to certain condition given in section 437 of the CRPC. If a person is arrested on the accusation of commission of any non-bailable offense, then the person will not be released on bail if there is appear a reasonable ground that the person is guilty of an offense punishable with death or imprisonment of life. But if suppose there is a punishment and he has done an offense of death, where the punishment is the death is there, or where the punishment is life imprisonment is there, then in that case bail cannot be granted and magistrate will not grant bail. A person accused with an offense punishable with death or imprisonment life can be released on bail if the person is below the age of 16 years. But in the case where the person is less than 16 years, in that case, and in that circumstances, if the magistrate think that yes, it can be a reasonable ground, then and then bail can be granted. One more condition, that a woman or a sick inform further if at any stage of investigation it appears, who will do the investigation? Investigation is done by the police officer under section 156, because as per 156 the procedure has been defined. If suppose a matter has been referred from the magistrate also, so 156 subclause 3 is applicable for investigation, and 157 of the CRPC where the procedure has been defined of the investigation. So now this is very much important, that a woman or a sick infirm further if at any stage of investigation, if it is found that a woman is there, or it is, or she is a sick woman, or it appeared that there are a reasonable ground for believing that the person has not committed a non-bailable offense, but it think that he has not committed a non-bailable offense, the person may be released. Because if he has not done the grievous offense, then at that point of time the person can be released at the discretion of the court while executing the bail bond condition. Now, in certain cases, in a case a person is accused with a commission or abatement or conspiracy or attempt to commit any offense against state. Now, let us suppose in certain cases state has filed for bail application, or with the offenses affecting the human body or the offenses against the property may be released on bail, but the court may impose the bail bond condition. So what bail bond condition court can impose? In 437 subclause 3, it has been specifically mentioned that the bail can be granted when he is cooperating with the investigating agency. He is available before the court whenever the court requires. He is not crossing the jurisdiction area. So all the conditions are being imposed while granting a bail bond. So coming to my next slide, can this bail be denied? The question arises that whether bail can be denied also. So as per section 436 subclause 2 of the CRPC, it specifically states that if a person has violated the condition of a bail bond earlier, suppose or earlier already he has been granted bail and he is violating that law and he is not obeying the law of the court, then the court may refuse to release him on bail. On a subsequent occasion in the same cases, he can also ask to pay a penalty for not appearing before the court. In certain circumstances, if court think that yes, he is not obeying the law, he is not obeying the conditions, in that circumstances, a penalty can be imposed by the courts in the proceeding against him. B can be, it has been specifically stated that it is clear that the provision related to the bail in case of a non-bailable offences give a discretionary power to the police and the court. And however, the power is not without any restraint. Section 437 disallows to be given a bail under following conditions. So what are the conditions where the bail cannot be granted? If it appears that there is a reasonable ground of believing that he has committed an offense punishable with life imprisonment or death. Suppose a person is doing he has committed a non-bailable offenses, he has committed a grievous offenses where the punishment is life or where the punishment is imprisonment or where the punishment is the death. In that cases, bail cannot be granted by the honorable courts. If such offenses is cognizable offense, now what is cognizable offenses? Cognizable offenses are those offenses in which police can arrest a person without warrant. And as per this cognizable offense, if such offense is cognizable offense, the person has been previously been convicted of the offense with death, then in that case, bail cannot be granted. So in that cases, I want to just explain that in certain circumstances, the bail cannot be granted by the honorable courts. Now let us come to anticipatory bail. It has been defined in section 438 of the CRPC, that is Criminal Procedure Code. Now what is anticipatory bail? In a case, a person is of the apprehension that he might be arrested on the accusation of non-bailable offenses. Means there is a consideration, there is a circumstances that he might be arrested. He can apply to which court? He can apply to the High Court or the Court of Session for a bail under section 438 of the CRPC. The grant of a bail will be on the discretion of the court, subject to certain conditions, including the condition that the person shall make himself available for interrogation by the police as and when required. Now, I will refer one judgment of Siddharam Satalingappa Mahatare, which is the leading judgment, and right now one more judgment delivered by the Honorable Supreme Court by the Constitutional Bench, where Justice M.R. Shah has delivered a fantastic judgment. I will come to that slide also. So, in anticipatory bail, if a person is make available himself for interrogation by the police as and when required. Now, the most important part in the anticipatory bail, the court has to consider that if he is ready to come with the interrogation, he is ready to for interrogation by the police, where whatever the timing by the court has been assigned, in that cases anticipatory bail can be granted by the honorable court. But no magistrate has the power to grant anticipatory bail. Only the High Court or the Court of Session has a power to grant a anticipatory bail. Now, second ingredient is that not make any inducement, threat or promise to any person so as to deter him from disclosing any material fact to the court or any police officer. Now, if suppose a person is going to induce, if he is going to threat, or he is going to deter, or he is going to remove any evidences, in that circumstances, if court has considered that if he is going to grant anticipatory bail and is going to do certain damages of the evidences, in that case anticipatory bail cannot be granted. Third, specifically, this is the major ingredients in 438, that he should not leave India without permission of the court. In certain cases, when the court is granting anticipatory bail, court will ask to surrender the passport also, so that he should not cross the jurisdiction area. So this is very much important ingredients, three ingredients which are very much specifically stated, that he should be available for interrogation before the police station. Whenever the police asks him to come to the police station, he can ask any question at that point of time. In that case, anticipatory bail, the court, the person who is applying for anticipatory bail has to fulfill all the conditions of 438. Now, procedure for anticipatory bail. In order to apply for the bail under section 437 or 438 of the CRPC, the accused is required to fill the form number 45 given in the first schedule and apply for bail. And after that, it will be the discretion of the court. Now, he should not say that, yes, okay, that is okay, that Article 21 says that no person should be deprived of life and personal liberty except there is a procedure established by the law. And if a person is fulfilling the bail bond condition, then it is okay. But after that, it will be a discretion of the court. So court has a wide discretionary power. If court think that no, the person should not be granted anticipatory bail, he can also, with certain condition, he can reject the application also. Coming to next, in Gurbakhsh Singh CBA and others versus State of Punjab. Now let us go through the fact of the case in this Gurbakhsh Singh case. Mr. Gurbakhsh Singh CBA, the appellant, was the Minister of Irrigation and Power of the government of Punjab under the Congress regime. He and a few others were facing a serious accusation of corruption and undue use of power. The minister, along with other appellants, apprehended the arrest. The appellant applied for anticipatory bail under section 438 of the code. So this is also one of the leading judgment in anticipatory bail. In the High Court, what had happened of the Punjab and Haryana, they prayed for the High Court to direct the appellant to release on bail in the event of the arrest on the basis of above stated charges. The application was dismissed by the full bench of the High Court, but on a special leave to appeal, the application was allowed by the Supreme Court. So this is one of the leading judgment of anticipatory bail. What was held in this case, the 5 judges bench was of the view that the discretionary power conferred upon the High Court and the session courts by the legislature can be accounted for the fact that the criminal justice system cannot be engulfed in the straitjacket formula, and the exercise of this power depend upon the fact and the circumstances of the different cases. And as no two cases have a similar fact, and the court must be provided with a free hand to exercise their power accordingly. According to Justice Chandrachud, the society has a vital interest in the right to the personal liberty and the investigational power of the police, even though relatively their importance depends upon the political conditions of the state at any given point of time. He highlighted that it was the court task to figure out how to strike a balance between the two and determine the scope of section 438 under the code of CRPC 1973. Justice Chandrachud has also pointed out the term in this case, in Gurbakhsh Singh CBI case, that reason to believe means the apprehension must be founded upon the reasonable ground and not just a simple belief or fear. The reason for this is that if an application for anticipatory bail is applied without any ground for the apprehension of arrest, the court gets overburdened with unnecessary cases and application. And this hamper with the efficient working of the judicial system. So this was one of the leading case. Now I am coming to one of the important case, that is in section 439, which is a regular bail. You can apply to the session court or you can apply to the high court. But when there is a provision in 439 subclause 2, you can also apply for the cancellation of the bail also. So in the leading judgment of Sanjay Chandra in regular bail, I am just going through the fact of the case in Sanjay Chandra. This is the 2G spectrum case entitled the fraudulent allocation of 2G bandwidth. Now, spectrum to provide the entities in the telecom sector, causing the executor an estimated loss of rupees 30,000 crores. Allegation of large-scale corruption and collusion resulted in the arrest of the former telecom minister and high-ranking bureaucrats and the top-level corporate executives. In May 2011, the Delhi High Court in Sanjay Chandra vs. CBI authorized the pre-trial detention even though the investigation was complete and there was no substantiated allegation of intimidation or tampering with the documentary evidence. In the process, it eroded the most fundamental tenet of criminal law, the presumption of the innocence, and this eventually resulted in the continued incarceration of the accused for 6 months, despite them not having been indicated for the offenses charged. And I want to add in this judgment, Ram Jeth Malani in para number 6 has been vehemently argued that if suppose there is a prima facie case, still bail has to be granted. That is, and in this case, the despite formal charges has not been framed under the CRPC. Now, in Sanjay Chandra, I am just going to one of the things that rejection by the high courts while rejecting the bail, suppose High Court want to reject certain bail, the High Court observed that being an economical offences involving the billions of dollars and the allegations were itself sufficient to deny bail. Moreover, despite cooperating during investigation, the court stated that their past action cannot be guaranteed that during the trial they will not interfere with the judicial process. But if I will quote the Ram Jethmalani argument in this case, it has been vehemently argued that if suppose there is a prima facie case, it can be a ground for regular bail in 439 of the CRPC of 1973. So this is one of the aspects in Sanjay Chandra. What is the decision by the Supreme Court in this case? It is 2012 1 SSC 40, page number 40. Decision of the Supreme Court that however, the Supreme Court granted bail to the accused. Now in this case, bail was granted in November 2011 in Sanjay Chandra versus CBI. Recognizing that the right to life and personal liberty was the most basic of all fundamental rights. So this was the most important ingredients in this case, and the court reserved the High Court order by taking the cognizance of the completion of investigation and the prospective delay in concluding the trial and the 6 months incarceration, stating that the right to bail is not the denial. It's merely that is simply because of the sentiments of the community against the accused. Now this is the one of the leading judgments which recently the Susila Agrawal judgment was there by the MR Shah in Susila Agrawal and others versus state, that is in NCT, that is 2020. This is the latest judgment, Susila Agrawal. Recently a 5 judges bench of the Supreme Court cleared that the confusion over whether the protection given to a person through anticipatory bail should exist. Now, this is one of the leading judgment, currently judgment, which has been delivered in February by the judges bench, where MR Shah is also there from Gujarat. So recently, a 5 judges bench of the Supreme Court cleared the confusion over whether the protection given to a person through anticipatory bail should exist for a fixed period. So the judgment was pronounced by a bench of Justice Arun Mishra, Indra Banerjee, Vinit Saran, M.R. Shah and S.R. Bhatt. Justice M.R. Shah and Justice Ravindra Bhatt penned a separate judgment agreeing with each other. And Justice Arun Mishra and Indra Banerjee and Vinit Saran concurred with the conclusion reached by both the judges. The Supreme Court in this leading judgment held that anticipatory bail should not be invariably be limited to a fixed period. But if there are any special or peculiar feature necessitating the court to limit the tenure of anticipatory bail, it is open for it to do so. So this is one of the leading judgment where it overruled the Siddharam Satalingappa judgment. I will go to one of the para of Siddharam Satalingappa, what was stated in Siddharam Satalingappa. Coming to my next slide, for the cancellation of bail. So, for the cancellation of bail, although there was no provision for cancellation of bail, but in the Talib's case, AIR 1958, it has been held that by the Honorable Court that the absence of such provision, not a lacuna, but as recognized the power of a High Court for the cancellation of a bail. According to section 437 subclause 5, it has been specifically stated that any court which has released a person of bail may direct a person to arrest or put into the custody. Suppose the Honorable Court has granted bail and if think that yes, now he has to be again arrested because he is going to hamper any evidences, he is going to damage any evidences, he has to going to damage any person, in that cases it can be cancelled. Section 439 CRPC also grant power to the High Court and the Court of Session to cancel the bail. In 439 subclause 2 also there is a provision for cancellation. But and put the person into the custody. The basic criteria for the cancellation of bail for the interference or even an attempt to interfere with the due course of justice or any abuse of the indulgence and the privilege granted to the accused. In Ram Govind Upadhyay versus Sudarshan Singh in 2002, Criminal Law General 1849 Supreme Court. Now I am coming to my one important judgment which I want to show in one of the leading judgment. Just in 2 minutes, I am just showing this judgment. In one of the leading case of anticipatory bail in Sanjay Chandra, it has been specifically stated in Siddharam Satalingappa Mahatare. The very fact issue was held in this judgment in Siddharam Satalingappa. I am just reading one of the head note of this 438. That in 438, which was followed by the CBI case, grant of anticipatory bail for a limited duration is illegal. An anticipatory bail after hearing a public prosecutor to orderly continue till end of the trial and per se in coriam decision what is and what its procedure value and legal procedure restated and Constitution of India under Article 141 that per in coriam decision, and Article 141 specifically state that not only the larger bench judgment but even the judgment of the co-equal bench reiterated binding, and if the court doubts the correctness of such judgment, then proper course is to be referred the matter to the larger bench. The present two judges bench and however held that the bound of earlier constitutional bench further held the judicial decisions obliges it to the courts, tribunals and judiciary to grant bail. Now I am just reading the last para of this judgment of Siddharam Satalingappa, which has been very much in one of the para which has been specifically stated that in delivering the judgments, this is one of the important judgment of anticipatory bail which has been overruled by in the February by the judgment by M.R. Shah. The proper course of action on application for anticipatory bail ought to be that after evaluating the averment and acquisition available, so the court has to check that what are the available evidences, what are the averment produced before on the dais on the record, and if the court is inclined to grant anticipatory bail, then the interim bail be granted and notice be issued to the public prosecutor. After hearing the public prosecutor, the court may either reject the anticipatory bail application or confirm the initial order of granting bail. The court would certainly be entitled to impose a condition for the grant of anticipatory bail. So this is also one of the leading judgment which has been overruled by the latest judgment of M.R. Shah. And coming to, I am just going to one of the another judgment of P. Chidambaram, which is 2019 9 SSC 24, and I'm just reading the head note of this for anticipatory bail, which the P. Chidambaram has applied. That power under to grant anticipatory bail and refusal to grant anticipatory bail held does not amount to the denial of the right conferred upon the applicant under Article 21 of the Constitution. The Honorable Court will check the nature and scope and power of 438, whether the relevant consideration while exercising the power, and particularly in the case of economic offences like money laundering. As you know that this was the one of the leading case, that is the P. Chidambaram case, and in that has been specifically stated that having regard to the nature of allegation and the stage of investigation, an investigating agency must be given a sufficient freedom in the process of investigation. An appellant not entitled to anticipatory bail as same would hamper the investigation. So this is very much important, and I'm reading one of the head note, one of the para in this judgment in P. Chidambaram, which has been specifically held. What was it held in this? The legislative intent behind the introduction of 438 of the CRPC is to safeguard the individual personal liberty and to protect him from the possibilities of being humiliated and from being subjected to unnecessary police custody. However, the court must also keep in the view that a criminal offense is not just an offense against the individual, rather the larger societal interest is at the stake. Therefore, a delicate balance is required to establish between the two rights and safeguarding the personal liberty of an individual and the societal interest. In one of the most para in same judgment, which has been in para number, I'm just going to that para. In this The argument by the Kapil Sibal, who has argued in this on the behalf of the appellant of in the behalf of Chidambaram. Mr. Kapil Sibal, learned senior counsel, in para number 10 of this judgment, Mr. Kapil Sibal, learned senior advocate, appearing on the behalf of the appellant, submitted that the cleaning of INX FDI was approved by the Foreign Investment Promotional Board (FIPB), consisting of the 6 secretaries and the appellant, and then the 5 finance minister granted approval in the normal course of the official business. The learned senior counsel submitted that the crux of the allegation that the appellant of the son Karthi Chidambaram tried to influence the official of FIPB for granting the ex post facto approval for the downstreams investment of INX Media to INX News, whereas neither the board members of FIPB nor the official of FIPB have stated anything about the appellant sons and Karthi Chidambaram, that he approached the influence them to ex post facto approval, and the learned senior counsel contended that the entire case alleges about the money paid to ASCPL, and Karthi Chidambaram is neither the shareholder nor a director. So ultimately, Kapil Sibal want to protect the Chidambaram, and it was duly influenced. And he has also quoted as per Article 21 that he is not going to. It is one of the. He has also given one of the ground in this judgment, and I am just going to the what was the basic held in this judgment. In the last para, in the result, the appeal is dismissed, and in this, the bail was dismissed by this court, by the honorable court, and it is for the appellant to work out his remedy in accordance with the law. And when the application for the regular bail is filed, the same shall be considerably by the London trial court on its own merits. So basically, when you are applying for anticipatory bail, the ground has to be checked by the Honorable Supreme Court or by any session court. When you are granting anticipatory bail, the Honorable Court will check that whether the gravity of the offence is very higher or lower. The Honorable Court will also check the person is going to interrogate will be going to fulfill the bail bond condition. In that case, the Honorable Court can grant bail in his conditions of the bail bond, and in certain circumstances, the Honorable Court will also try to. The Honorable Court will also try to give a bail in certain cases. When they think that yes, there is a proper ground and there is a reasonable ground, then and then bail can be granted. But in case of Sanjay Chandra, where Ram Jethmalani has specifically stated that if suppose that there is a proper ground and the person is furnishing the COT and there is a provision that he has been the evidence has not been come in before the Honorable Court, in certain cases bail can be granted. 437 is there, where the bail you are applying for the magistrate, it is not mandatory, and if suppose the condition that you have done a serious offense, you have done a cognizable offense, you have done a very non-bailable offense, in that case in 437 also bail cannot be granted. So this is very much specific as per the bail is concerned. Now, one of the leading judgment in last, which has been specifically stated as per the judgment in Siddharam Satalingappa and this Sanjay Chandra, because Sanjay Chandra has been very much specific judgment, and the advocates are, when they are arguing for the regular bail, they are putting Sanjay Chandra, because in this, and I am just telling you, in this judgment, as per accused number 16, I am himself available in this when this trial was running in the Patiala house. For the accused number 16, as per the Kannimoi, because my senior advocate who is the standing counsel of Karnataka, and I was making a notes of this, so I have learned various things that how these arguments are being done. So as a student, just I want to explain that whenever you are applying for the regular bails or whenever you are applying for the anticipatory bail, you can apply this judgment which has already been stated with the last slide, which had been stated in this judgment of Susila Agrawal and others, because this was the later judgment where this was overruled, the Siddharam Satalingappa judgment, because until the person has not been completed the trial has not been completed in that circumstances and there is no evidence, so why that person should not be granted bail? In certain cases the bail should has to be granted, and this was the leading judgment of Susila Agrawal, which has been delivered in February 2020 itself. So, as per the regular bail and anticipatory bail is concerned, the conditions of the bail in anticipatory bail 437 subclause 3 has to be incorporated, and the court has to be checked that whether there is a ground that is going to hamper any evidences. In that case, bail anticipatory bail cannot be granted. But in case of a regular bail in 439, where the Section Court and the High Court has the power to grant bail, in that cases, bail can be granted while checking the evidences. If suppose he has done a murder and there is an evidence, in one judgment, I am just quoting one of the argument by myself in the Honorable Supreme Court before Justice Bobde. There was one of the matter of Ghela Bhai, Chattar Bhai in court number 12. I was arguing in this matter, where there were 6 accused, and I have argued in this matter in the case of regular bail, and in this case I have stated the court my coping he is able before the derogation, so why should not be granted bail? So certain judgments, how to argue whenever as a student you are arguing in certain matter, you have to check whether the grounds of 439, the ground of 438 is complying or not. If you are making your drafting and you are incorporating this, you have to incorporate all the judgments, recent judgment while arguing the bail. And you have to impose that bail bond condition, you are also complying with bail bond condition. So this is very much specifically stated. You have to, while drafting this matter, you have to specify the things in a very correct manner while applying for the bail applications. So as per this, to sum up this session, I can say that this is for the bail. It is very much important that whenever you are applying for anticipatory bail, you have to incorporate the ground that the person is not going to abscond. The person is going to interrogate with the police officer whenever he required, and the person, there is a gravity is very lesser, and that there are certain ground that previously also, and he is a good reputed person in the society. Okay, if suppose you can also incorporate Article 21, that if there is no evidence, why he should be deprived of Article 21 of the Indian Constitution. So these are the very much important ground in while arguing in the matter of anticipatory bail. And in regular bail, this is one of the leading judgments, Sanjay Chandra, I have already explained. And as per the para number 6, which is very much specific in that judgment in Sanjay Chandra, because you know why the person should be unnecessary restraint until and unless in certain I have seen various ground in 167(2). Charge sheet was not submitted. It is also one of the ground. If suppose charge sheet is filed in 173 of the CRPC, but in certain cases the charge sheet has not been submitted by the in charge police station to the magistrate. In that circumstances, it is one of the ground in regular bail that you can say that already charge sheet has not been submitted and the person is inside the jail without evidences not being produced. So in that cases, in regular bail in Sanjay Chandra, you can take certain grounds and you can apply for regular bail in 439. But as per the Arnaz Kumar, after coming of Arnaz Kumar, it has been in the case of cruelty in 498A. Now the Honorable Supreme Court has given, and after that, Sosa Young Lawyer judgment has came. So there are various judgments where it has been specifically, you have to, as a student, you have to go through each judgment, each para, and then understand and interpret the law. Because interpretation of the law is not an easy case. You have to go through the each and every aspect of the bail while arguing the bail application. You have to refer various judgments. If suppose you are arguing in anticipatory bail, you have to refer Guru Baksha Singh Sibia, then Siddharam Satalingappa. Then please note down that citation. Already I have explained in the CD, and I can share this CD to Mahesh Patel sir, so that he can share to all the viewers So it is this I have read yesterday. But while reading the whole judgment, you have to go through the depth of the judgment. Because if I will go to the judgment, it is a judgment of more than 100 pages. So you have to specifically read each and every argument. Say for example, in P. Chidambaram case, the argument of Kapil Sibal was there. So you have to go through what argument he has put it. To make his bail, but in that case the bail was rejected. But he's taking that things. So you have to take all the things in your notes while arguing in the matter. So if any questions or anything you can ask at this point of time, and then I will end my session. Mahesh Patel sir. Hello, your voice is not coming, sir. Hello, yes, yes, sir. Yes, sir. Yes, sir. Yes, any student or any faculty can ask any question pertaining to this bail provisions.
जी महेश भाई thank you. Thank you. First of all, thank you Mahesh sir for giving me the opportunity for this vote of thanks. And also today in today's session our speaker Dr. Rajesh Singh sir has clear our concept about the bail with latest judgments. It is very important because with latest judgment you can convince the court. As we all know, the bail is discretion power of the court. So we have to convince the court. So latest judgments are very important.
You can share this slide to all the viewers if you want. You can share the slides. Okay.
Yeah,
I will
definitely,
send to you.
Definitely. Thank you, sir. And Rajesh Singh sir also told that Gela Bhai Chatar Bhai case, he successfully get the bail from the Supreme Court. So this totally is very interesting session. We learned a lot from Singh sir. So thank you very
Hello, sir. Sir, I think he is disconnected.
It's an electricity problem. Sorry for that. Thank you very much, sir, for giving this interesting lecture. And I also thank you on behalf of SM Shah Law College Mehsana, Law College Himmatnagar and Modasa. Thank you very much, sir.
Thank you.